There continue to be many changes in regulated procurement that the public sector and suppliers need to factor into their procurement strategies. Two issues to highlight are the interaction between procurement and the GDPR and recent case law on rights to exclude bidders for failing pass-fail criteria. The Crown Commercial Service has published a procurement policy note requiring the public sector organisations to act immediately to ensure compliance with the General Data Protection Regulation, the GDPR, which comes into force on the 25th of May. Contracting authorities need to carry out an audit to identify existing contracts involving the processing of personal data that will be in place after the 25th of May and ensure that they are compliant with the new legislation. This is going to require variations to existing public contracts, so suppliers to the public sector should expect engagement with their clients on this issue. For contracts awarded after the 25th of May, contracting authorities will need to carry out due diligence of new suppliers to ensure that they can implement the appropriate technical and organisational measures to comply with the GDPR, and that the terms and conditions reflect all of the necessary clauses. Suppliers should expect that failing to give evidence with compliance with the GDPR will give the procuring authority a right to exclude a bidder from a procurement process. There continues to be a lot of public procurement case law, both within the UK and Europe. In a recent UK High Court case, the Ministry of Defence was challenged by an unsuccessful bidder, whose bid for a £350 million contract for logistical support services was deemed non-compliant. The key practical point from the judgment for contracting authorities is that if you want to retain the discretion to reject a bidder if it fails a criteria that is evaluated on a pass-fail basis, the invitation to tender must explicitly reserve this discretion. It is not sufficient for a contracting authority to think that it's implicit in a pass-fail criteria that a fail will allow the authority to reject a bid. In this case, there was no such wording in the ITT, the invitation to tender, and accordingly, the claimant who had been rejected for failing the pass-fail question, where the Ministry of Defence had not explicitly stated that a fail could lead to a rejection of the bid, had its claim upheld by the court, and a declaration was made that the Ministry of Defence had acted unlawfully in rejecting its tender. The MOD's explanation for the absence of the wording was that it was an administrative error, which, as it turns out, was a very expensive error. There are further interesting cases due to be heard in the Court of Appeal and the High Court in early 2018, in particular on the legality of public sector land development projects, which are set out in the regulatory outlook, and we will continue to provide updates on these as judgments are made.